Hi, everyone. It's Evelyn Aka from Aka Business Immigration Law. Thank you so much for joining us on our LinkedIn Live. Apologies for being a few minutes late. Today, we're going to be talking about all the changes with the intercompany transfer provisions in the immigration policies in Canada. At Aka Law, we use the intercompany transfer strategy quite a bit for our corporate and professional clients who have businesses who want to move to Canada and establish a business in Canada. So I'm going to go through a lot of the changes and I will be reviewing them on paper because I want to make sure I capture all of the significant changes. So the first change is they've now separated more directly those treaty countries that have treaties with Canada. So for instance, the US and Mexico and Chile, we have free trade agreements with Peru and other countries that contemplate the intercompany transfer. So they're separating those requirements for those treaty countries versus those with that are non-NAFTA, for instance, or that don't have treaties, like people from China or Nigeria. And this is very significant because if you are not in a treaty country, the requirements are different. So we're going to talk first about those that are lucky enough to be coming from a treaty country, such as Mexico or the United States to Canada. Overall, the provisions have become more strict and tighter. So one of the main things you need to know is they're going to be reviewing intercompany transfers. If you're coming from Mexico, let's say, or the US, you will qualify to be able to transfer by setting up a Canadian entity. And you only need to be coming from one company in one country into the next, into Canada. The multinational corporation requirements are not going to be as strict for countries coming from for companies coming from countries that have treaties. So it's really important to understand that. We're also seeing that they're going to be focusing more on the specialized knowledge worker and looking very closely at what is considered specialized knowledge and looking at why your perspective and your experience is considered specialized knowledge. So we're looking at that as well. Those that are coming from a free trade agreement country will still be looked at closely. They'll have the specialized knowledge and the manager and managerial, but there are also some real changes that you need to know about. So for instance, they've clarified, as I said, the specialized knowledge category. It's been clarified, and applicants must demonstrate that they really meet the facets of specialized knowledge, not just saying their job is specialized. You have to prove it and show it's proprietary and what makes it so specialized, or you won't get approved. They must also show that the position they hold in the foreign company will still be available to them when they return. So they're looking at ways to show that even if you're transferring, it's meant to be temporary. It's not meant to be permanent. Obviously, things can change. When you come to Canada, you can change your intention and go from a temporary intention to a permanent intention. But for now, you have to make sure you reflect that the job will be waiting for you when you return to your home country after you complete your assignment in Canada. The applicants must show a clear employer-employee relationship with the Canadian company. And that means that they must be directing the day-to-day activities of the foreign worker, the Canadian company. So this is meant so that you're not just parachuting in people to do something and then go back. They need to have a real connection and be supervised and managed by leadership in the Canadian company, even if it's a brand new company. So those are really important. They've also clarified how to deal with a change in category. So for instance, you might have come in as a specialized knowledge worker and somewhere in the process you are promoted to manager. We have to really show that and ensure that they remain compliant. Historically, if somebody came in as a specialized knowledge worker, which means they only had 5 years total on their work permit term, but they got promoted to manager or senior executive, they would have to show why that they were staying an extra 2 years, which is what you get when you have the manager and executive category. You get to spend up to 7 years in Canada. So now the requirement is you have to show that you're compliant and that the new work permit is obtained prior to a promotion or change in employment terms, and explaining why the promotion. Because strictly speaking, the type of job you come from, if it was managerial in your home country, should be managerial in your Canadian entity business. So it's very difficult to usually stay in the Canadian business and go from specialized to manager. They're now making it even more difficult. So one of the things I really want to focus on is what they mean by multinational corporation. This is becoming a very, very important distinction because for a NAFTA or free trade agreement application, you can be coming from your home country, as I said, to the Canadian entity. But if you are not in a multinational corporation country that doesn't have a treaty, like say, as I said, China or Nigeria, that multinational enterprise must be in two different countries operating. Two different countries operating the business actively in order for you to qualify to then set up the third entity in Canada. That is the key and most significant change with the intercompany provisions now. For non-treaty countries and companies, you must have two or more entities in operating actively and with employees, etc., before you can then be qualified to apply for intercompany transfer. So this is a very big change that is affecting people who we were in the midst of doing applications for, and we'd have to pivot and change because they no longer qualify if they only have one company in the country they're coming from to qualify. So that's really important. You also must show that the relationships between the multinational company outside of Canada is related to the Canadian enterprise. And so that means establishing the new company in Canada and providing a timeline and supporting evidence to establish when you're going to start doing business. A strong business plan is going to be required. You must have maybe the presence of an agent or an office, and you must actually have an office, not just like a Regis space or one of those shared office spaces. You must be able to show that you have a physical location, that you will not be working from your home. So these are some of the things that they've really emphasized more and more with the changes with the intercompany. The multinational component is very, very difficult. And if you're not sure if you qualify and you're not sure if you have a treaty country citizenship that qualifies, feel free to give us a call and we can go from there and see if we can assist you with that. As I said, the significant benefit to Canada, you must also show that the multinational company, the intercompany transfer, is going to have significant benefits to Canada. Creation of jobs, social or cultural benefits, financial benefits, taxes being paid, all of that. You need to really build out what the strategy is going to be to grow the business in Canada. It's not just enough to have the company here. You must also be paying prevailing wage for your managerial intercompany transfers. So this is significant. It used to be only the specialized knowledge had to be prevailing wage. Now the managerial and executive must also meet the prevailing wage criteria. So these are very big changes that have occurred recently and that are definitely upending a lot of people's plans, and maybe those that benefited before are not going to be able to qualify now. And now the question becomes, what happens if you're already here on intercompany transfer and you want to extend your status? Now you need to think about these new provisions, because if you don't qualify, we may not be able to extend you further. And you need to get yourself to permanent residence as quickly as possible. So some of these changes are significant and they're going to impact people. So I'd love it if you can give us a call. If you are an intercompany transfer that we've helped before, you have a work permit right now and you're thinking of extending it, we need to talk and plan a strategy well before you need to. And if not, we have to look at, do you have other options and will you qualify for permanent residence now? Because if so, we need to get you there sooner than later. I hope this LinkedIn Live has been useful. Really, it was just to prompt you to understand that intercompany provisions have changed significantly. Lots of scrutiny, and they're looking more closely at looking for reasons to refuse applications. So we want to make sure you are successful. So please do call us at ACA Business Immigration Law. We'd love to help you sort through these changes and make sure you qualify to the best of our ability before we start your application. Take care, and until next